Hey everyone, good morning, good afternoon, or good evening, depends when you're watching, or perhaps maybe good night if you're just using this video to go to sleep. My name is Professor Ramirez. This is Business Law. We are in week 7, and for today's show, we're going to be discussing Chapter 11, Performance. Again, this PowerPoint is uploaded already on Blackboard. So I encourage you to follow along with the PowerPoint presentation. And again, as I've mentioned, if you were to read Chapter 11 prior to watching this video, I think it'll help you guys a lot more to understand the material and the subject matter as we move along in the chapter. Previously, we discussed 3 previous chapters on contracts. This is Chapter 11, the 4 out of 4 of those chapters dealing with contracts. So from these 4, the 3 previous chapters and Chapter 11, we're going to they're all going to bring together the topic of contract with these 4 chapters. But if you have any questions, like always, don't hesitate to reach out and let me know. But let's move on to the next slide and talk about some of the learning objectives of what we expect to learn from this video. Okay, thank you. Jumping on here to slide number 2, the chapter learning objectives of what we're going to learn on this chapter 11. So hopefully after we go through this, we'll have to first after you read the chapter and follow along with the PowerPoint to watch this video. One of the things we're going to learn that you're going to identify and categorize the 3 types of contract conditions. 2, you're going to be able to explain the doctrine of substantial performance and identify its effects on the contracting parties. 3, you're going to describe 4 ways the contracting parties can discharge a contract through mutual assent. And then 4th and final, what the last thing you're going to be able to do or identify is describe the 3 ways the contracting parties or the parties to the contract can discharge a contract through the operation of law or through laws. So those are the 4 things. Obviously, there's more that you'll be able to know and you're going to be able to discuss and identify. However, these are 4 of the 4 main topics that we're going to discuss here in Chapter 11 and this video. So let's go on the next slide and keep discussing this. Now getting on to here to slide number 3, which is the nature and effect of contractual conditions. Now the conditions, we're going to discuss 3 different types of conditions. First, the condition precedent, the condition subsequent, and the condition concurrent. Now the first one, for condition precedent, this means the condition must occur before performance is required. Now one example of this is, say for instance, a company hires a sales representative, and part of the contract for the sales representative is the company will provide him or her $1,000 bonus if within the first month that sales representative can get 10 new accounts. So it's saying that example, let's say in the first month, the sales rep was only able to open 9 new accounts. So before the bank or before the company has to perform that or provide that $1,000, the condition that must happen before was that those 10 accounts. So because that condition was not met, the sales rep only opened 9 accounts, then no performance is necessary by the company to provide those $1,000 because that condition precedent was not met. The 10 accounts were not opened. Now the second one, let's go with condition subsequent. Now the condition must occur after performance. Otherwise, the duty to perform is subsequently discharged. Now in this example, say we have an employer, the same example, hires an attorney. But when they hired the attorney wasn't licensed yet. So the condition of still being employed with the law firm, with the company, is that law student who graduated law school but hasn't passed the bar, the company may say you have 1 year from when you first started working with us to pass the bar. So that performance, he started the job, we gave you a job, but it has to be performed after that. So then at that point, the company will wait a year. If that individual doesn't pass the bar or doesn't get his law license within 1 year, then that company may let him go, or doesn't have a duty to keep employing him, because the condition subsequent, that after you started, that condition that was supposed to be met after was not met. So therefore, they would probably just let him go and fire him. Now the third one is a condition concurrent. Now this state, each party's performance depends on the other's performance. So this is usually met at the same time. One example of this is, and these examples are in your book, perhaps on page 247. Say for example, there is a painter, and a lady comes to him and tells the painter, I want you to paint my portrait. I want you to paint a painting of my face for a picture. If the artist does the painting, and then at the time that he hands the painting over to the customer, then that's when the customer has to pay the amount that was agreed to. So that's the condition concurrent. They happen at the same time. When the painting is given to the customer hands the painter the amount for the painting. So those are the three conditions and examples. The condition precedent, something must occur before a duty arises. The condition subsequent, the duty arises, but something still has to happen after. And the concurrent condition, both duties are at the same time. And that's usually what we see in a simple sale agreement or something like that. And that's the third one, the condition concurrent. Okay, well let's go on the next slide and keep talking about these things. Now here, discussing slide number 4, we're going to discuss discharging obligations through good faith performance. Basically, when one party relieves, doesn't have a duty anymore because they performed their obligations or their responsibilities in good faith. Now, if promises to perform in a contract are not conditional, meaning they don't have to wait for something to happen, then the duty to perform is obsolete. Most frequently, parties agree on contractual terms and perform their obligations in good faith just to complete the contract. Now, in these cases, both parties are going to discharge their obligation basically by complete or fulfill their obligation by just performing the duty that was bestowed upon them or completing their responsibility. So for example, when one client is shipping goods or delivering a good to another client, when they drop off the goods at the client's warehouse, they've already completed their part of the bargain there, so their performance is discharged. They're no longer needed to do anything else because they've already performed their part of the deal. Now, for an example, also there's something called an assignment of a contract. Now, this occurs when one of the contracting parties transfers their rights to another person. The original party with duties under the contract must still perform as required under the contract. Now, for example, this is, say for instance, I am shipping you bananas, and you order from me to drop off from a grocery store 100 bananas to you. Now, and for $1 each. So when I drop off 100 bananas, then you owe me $100 each, $1 for each banana. However, so we and you agreed to that example, to those terms. When I say that I assign my contract, that means I'm a grocery store. I can assign it or transfer it to another grocery store. So when that grocery store number 2, delivers 100 bananas to you, you owe grocery store number 2 $100 because I assigned him my contract, that grocery store. So it's not the person buying the bananas cannot get out and say, you know what, I contracted with grocery store number 1 for 100 bananas, but grocery store number 2 was the one that delivered the bananas. Therefore, I don't have to pay anybody because I never contracted with store number 2. No, that's not true. If I'm store number 1 and I contract with you for the 100 bananas, and in my contract or in the contract, it says I have the right to assign my obligations to another person or another party, and if you agree to give me that right, then you are still bound if grocery store number 2 drop off the 100 bananas. As long as the terms are the same, that the 100 bananas are still in conformity with what you agreed with store number 1, if you get delivered exactly what you wanted, what you agreed to originally, then you would still owe store number 2 the 100 bananas because I assigned my contract, my rights, and the rights that I got to pay to get $100 from you when I deliver 100 bananas. I transfer those or assign those to grocery store number 2. So at that point, you are due. The person who received the bananas is now obligated or bound to pay the $100 from a grocery store number 2. So that's the assignment. I just wanted to make sure that that's very common in a lot of contracts. So I just wanted to make sure you understand and you know what an assignment means. Well, let's jump over to the next slide. Now here, jumping on to slide number 5, still sticking with the discharging the obligations through good faith performance. Although the good faith requirement, it's going to be ordinarily met by the parties simply performing their obligations completely or 100%. And if someone performs their obligations 100%, it's easy to say that you met perfect performance. You performed your part of the contract perfectly by completing 100% of your duty or obligations. However, the law recognizes that there are some cases in which one party does not perform completely or 100%, yet they still acted in good faith and is still entitled to enforce the remaining obligations in the contract against the other party. Now, even though this is not perfect performance. This is something when a party completes maybe 95% of their responsibilities or obligations, yet the law still says you did not perform it completely, yet you still acted in good faith, so you're still entitled to enforce the contract toward the other party. So this is something we're going to keep talking on the next slide about, but I just wanted to let you guys know that there's something called perfect performance. That's when you did everything you were responsible for, you completed the contract, therefore there's no question that the other party owes you money in one case, or that the other party still owes you some goods or services. That's perfect performance. But there are cases when somebody does not perform all of their obligations or all of their rights or all of their obligations or duties or rights. However, they may still say, although I didn't perform 100%, you still owe me what was agreed to. So let's go on the next slide and talk a little bit more about this. Now going on here to slide number 6, this is still feeding off the prior slide where we said there's a party who did not fulfill their obligations or their rights 100%. So the law recognizes that a party's good faith efforts to substantially perform their obligations by allowing substantial performance to satisfy the requirements of the agreement and trigger the other party's rights, obligation to perform their contract. So this is called substantial performance. Now, in order to prevail in a substantial performance case, again, remember, substantial performance it's not perfect performance. It's not when you did 100% all of your obligations or your duties. It's when you substantially completed your obligation. Now, to prevail in a substantial performance case, the party trying to enforce the contract, the party trying to enforce it who almost did everything they were supposed to, they have to prove that they acted in good faith, and that any deviation, basically the deviation what they went to the side from, any deviation from the required performance, what they were supposed to do, was not material. Now, material, that's going to refer to some deviation from the contract, that results in a substantial change in the value of the contract, or the change is a fundamental basis of the contract. So that is a material change. That is something that's very important to the contract. It's going to change the value, the large value of the contract, or it's going to change the fundamental basis of the contract. Now, in order for someone to say, I substantially performed it, I performed most of it, therefore I should still make the other party pay me, they have to show that they acted in good faith and that the change or the deviation was not material. So in this example, say a manufacturer was supposed to give the retail company or the realtor 1,000 pairs of jeans. So if the company didn't make 1,000, but they made 990, and they delivered it to the retail to sell, that retail cannot say, well, you delivered 990, we contracted for 1,000, therefore I'm not going to pay you for any of these jeans that you delivered. Now they would argue, well, we substantially performed our obligation, and we met the substantial performance requirement. We acted in good faith to try to give it to you as quick as we can. We gave you 990. It's in good faith. Perhaps maybe we left the other 10 at the store. They'll be delivered next week. The other 10 to complete the 1,000. And that 10 pairs of jeans, that's not material to the overall 1,000 pair contract. And it doesn't change the fundamental basis of the contract. You wanted 1,000 pairs of jeans. I delivered 990. I know I still owe you 10 pairs of jeans, but you know what, maybe there was a box that stayed at the warehouse. Next week your other 10 pairs of jeans are going to be delivered. At that point, they acted in good faith. They can't say, the retail can't say, you know what, no, we don't want this contract because you failed to deliver 1,000 pair of jeans. I think a court will hold this is it was substantial performance. They substantially performed their obligation. The 10 pairs of jeans that was missing, they left it in the warehouse. They acted in good faith, and it's not really material. They're going to deliver it. They're going to deliver the other 10 next week. So that may change. Obviously, they're only going to pay for 990. That's fine. But when the other 10 get delivered, they'll still pay for the other 10. So that's an example of perhaps maybe where substantial performance can come into play, and where one party has that defense that say, you know, you still owe me for 990, and the retail can't fall back and say no because I ordered 1,000. So that's just an example of where substantial performance is. But let's keep on going to give some more substance on these things. Jumping on here to discussing slide number 7. So we're still sticking with substantial performance. Although the doctrine of substantial performance allows a party to meet their obligations in a contract through perhaps maybe through less than perfect performance. Now the innocent party is still entitled to collect damages to compensate for the imperfect performance. So in the example for the jeans, the manufacturer who perhaps maybe didn't deliver 10 jeans, now they're not going to just get out of it and say, well, I didn't deliver all of it. It's substantially performed. You still owe me for 990 pairs of jeans. Now that retail is still entitled to collect damages. So of course they're not going to pay for the other 10 that weren't delivered. But perhaps maybe if they were going to sell the retail, and they already had a buyer, a customer that was going to buy 1,000 pairs of jeans, at that case they can say, well, although I owe you for 990 pairs of jeans, but those 10 other pairs of jeans I was going to sell, I lost the profit from those because you did not deliver. They can subtract that profit they would have gotten for those 10 jeans that weren't delivered out of the cost they're going to pay for those 990 jeans. Now, just another point. Generally, the courts, they're going to allow the substantially performing party, say for instance the jean manufacturer, to be paid the full amount of the contract price, of course, minus any less any costs suffered. So obviously, they're only going to pay for the 990 pairs of jeans, but then also if there's any lost profits, that will also be taken out of the price of the 990 pairs of jeans. So although one party may say as long as we substantially performed, then at that point we're going to still perform. This stops people from, hey, if let's contract for 1,000 pairs of jeans, although I know I can only make 990, it doesn't matter. I'll just deliver 990 and they'll just pay me for 990. No, it's not that easy. You can't just get out of it. Although you're still going to be paid for the 990, they're still going to subtract certain things. They're going to subtract the damages, the cost, anything that the retailer lost because they were not delivered 1,000 pair of jeans. So it's, although you're going to pay 990, it's going to, for 990 pairs of jeans, it's going to be a lot less because they're going to subtract the cost and the actual damages from there. So just something to note, that just because you're going to rely on substantial performance, it's not easy. There are still consequences for not performing your contract fully. Okay, let's go to the next slide here. Now discussing here slide number 8, the discharge of a contract by mutual agreement. Now, under the principles of the freedom to contract by or for the parties may agree to mutually terminate their original contract or their obligations by using any of the 4 following methods. Recession is going to be 1. Accord and satisfaction is going to be 2. Substitute agreement is going to be 3, and novation is going to be the final one. In the next couple slides, we're going to go over these 4 ways to mutually terminate the contract or the obligations of the parties. So let's jump to the next slide and discuss these. Now here, excuse me, here on slide number 1, it's going to be the discharge by the first one for the discharge by mutual agreement. The first one is going to be the rescission of the contract. Now, if neither party has fully performed basically if they fully perform their contract, both parties may agree to just cancel the contract by both of their agreement. Now this cancellation is known as rescission, and each party gives up their rights and obligations under the contract in exchange by a release by the other party from performing their obligations. Now this can be also, perhaps maybe some people call it a mutual release, where both parties release each other from the obligations of the contract. But rescission or a mutual release is only going to occur, the most important thing, if both people agree to rescind the contract. A unilateral rescission basically means if only one party wants to cancel or void the contract, that's not permitted. Obviously, if only one party, perhaps maybe the other party still wants the contract to be fulfilled, then a unilateral rescission by one party isn't going to be able to cancel the contract. However, this rescission is almost also called a mutual release, where both parties have not performed the contract and both parties just want to cancel the contract by an agreement. So that's an easy way to get out of it. They both parties agree, the rescission. But let's jump on the next line and talk about the next way to cancel the contract. Now here discussing slide number 10, the accord and satisfaction. Now in some cases, the parties to a contract agree to accept performance that is different from the original promised performance. Now under the doctrine of accord and satisfaction, one party agrees to substitute performance in the future. This is known as the accord. And the other party promises to accept substitute performance in discharge of the current obligation. For example, if Peter agrees to paint your house for $1,000, Peter finishes painting your house for $1,000, but however the homeowner says, I don't have the money right now, but in 30 days I'll come back and I'll pay you $1,100. That's the accord. That's a substitute performance. Peter finished painting the house. He was owed $1,000, but the homeowner did not have the $1,000 at that time. So in 30 days, he told Peter to come back and he'll pay him $1,100. That was a different performance, the substitute performance. So that can be an example of an accord and satisfaction. The accord is the actual substitute performance. The promise to pay not the 100, because that was the original part, but not to pay that, but the promise to say, can I change that, my original obligation, to pay you $1,100 in perhaps maybe in 30 days. That's the accord. Now let's go to the next slide and keep discussing about the accord and satisfaction. So here discussing still on slide 11, still discussing the accord and the satisfaction. Now we'll stick with the example about the painter. Now once the substitute performance, the promise to pay the $1,100 in 30 days, has been rendered, this acts as the satisfaction of the obligation. So satisfaction of the original contract. Now the discharge of the obligation, the discharge of having to pay the painter. Now this only happens when the accord is performed. Obviously when the accord was the time when he said, I can't pay you the $1,000, but I'll pay you $1,100 in 30 days. That's the accord. Now when that is satisfied, that is when obviously the contract has been satisfied or has met satisfaction. Now if the accord promise, they didn't pay the $1,000, but the accord was to pay $1,100. If that is not rendered or performed, then the painter, has the option to recover damages or to sue under either the original contract, which is for the $1,000, or under the accord contract, under the promise to pay the $1,100 in 30 days. Since the painter the payer, the homeowner, did not meet the satisfaction of the accord or the original contract, the painter can sue on both of them, or whichever he wants, which will most likely be the $1,100 because it's a higher rate, but he has a right to perhaps maybe choose which one he wants to sue under. Let's go on the next slide and discuss the other way we can try to get out of a contract. Now discussing here on slide number 12, the substitute agreement. Now contracting parties may discharge their obligations or get rid of their obligations by replacing the original contract, of course, with the substitute agreement. Now the substitute agreement, this is generally going to be used to be used as a compromise when the two parties perhaps maybe they have a dispute on the performance of the contract and wish to amend some of the terms in the agreement or the contract. Now, when this substitute agreement is entered into, this substitute agreement immediately discharges or does away with the obligations under the original contract. Now, for example, let's sticking with the painter agreement. I don't know why, but say Peter the painter painted the house for $1,000, and he wants to enter, and he was owed $1,000 for painting it, and he wants to enter into a substitute agreement. Say, you know, those terms were completed. However, I will enter into new agreement, a substitute agreement with the owner that says, you know, I painted your house. Once I painted your house, you owe me $1,100 in 30 days. Then that he may wish to perhaps maybe get rid of the old contract and have the new one for $1,100. I would recommend that Peter doesn't do that. Have both contracts to just have an accord. They just kind of amended the original contract, so the party, the homeowner who didn't pay, Peter has the right to sue under both contracts. But perhaps maybe there's another situation when Peter wished to paint the house. However, perhaps maybe he didn't paint all the house, and the homeowner says, okay, you didn't paint all the house, Peter. You painted 75% of the house, so I was supposed to pay you $1,000, but let's agree on $750 then, because you only painted 75% of the house. Let's do a substitute agreement and say you would pay 75% of my house, and I'll pay you $750. In that case, that's going to benefit both of the owners, because perhaps maybe there was a dispute on what both parties were supposed to do. So that's in one way where a substitute agreement would work for the benefit of Peter to say, I was only supposed to pay 75% of it, so you paid me $750. Well, let's jump on the next slide and keep discussing other items. Now discussing here slide number 13, which we're going to discuss a novation. Now, when parties agree to substitute a third party for one of the original parties in the contract, the agreement may be discharged through a novation. Now, essentially, a novation is going to be a kind of a substitute agreement that involves the substitute of a third party rather than a substitute of a promise or a term or a condition in the contract. Now, a novation revokes and discharges all the replaced parties' obligations under the old contract. So let's stick with the St. Peter and the homeowner, Peter the painter example here. So if Peter the painter promised to paint the whole house for $1,000, and he was going to start tomorrow, but perhaps maybe Peter got a very large job and he wants to substitute a painter, and Peter comes to the homeowner and says, you know what, I'm honest with you, I got a very big job that I want to do, that I just got contracted for. I would love to substitute myself, Peter, and I want to put Pablo in my place. I think Pablo is a great painter. I can vouch for him. He does a great job. So in that case, the homeowner can say, okay, you're fine. You can go do the other job, and Pablo can be the new painter for the house. Now in that example, they just replaced one party. They replaced Peter with Pablo. But now Pablo is still bound by the same terms. The terms did not change. They just basically replaced one party into the other. So Pablo is now responsible to paint the house for $1,000 under the same conditions and quality and paint and all of those things, which was originally agreed to with Peter. So let's go on the next slide and discuss a little bit more. Now jumping on slide number 14, the discharge of a contract by the operation of law. Now, in some cases, after the parties have performed a contract, unexpected events occur that may affect one party's ability to perform the contract or to perform their rights or perhaps maybe their responsibilities under the contract. Now, in such cases, the law may allow the parties to be excused from performance under this contract. Now, courts they're going to analyze these special circumstances according to three separate doctrines or three separate laws. First one is going to be the impossibility. The second one is the impracticability. And the third one is the frustration of purpose. Now, those three are ways for perhaps maybe an individual to get out of the contract, but it would be up to the court's decision to determine that. In the next slides, we're going to talk about these three doctrines or these three laws, how a party can get out of the contract. So let's go jump on these next slides and talk about these three items. Now, jumping on to slide number 15, it's going to be the discharge by operation of law, and we're going to discuss one of the three ways first one is the doctrine of impossibility. Now, the impossibility, now this doctrine is going to be it's going to be objective. A reasonable person would have considered impossible to perform. Now, this is not going to be subjective. This is not going to be just based on the person who can perform. It's just whether, in his view, does he decide if it's impossible? No, it has to be subjective. Reasonable people, or basically think of a jury, has to decide that it was impossible to perform the contract. Now, the modern trend of the court is to go against this. They're not going to allow people to not perform contracts based on the doctrine of impossibility, unless the excuse of impossibility falls into one of the four categories. The first one is going to be destruction of the subject matter. So, for instance, maybe a warehouse, you contracted with a warehouse to deliver 1,000 pairs of widgets to the retail on Tuesday. But on Monday there was a big fire and the warehouse burned all the 1,000 widgets. So that's going to be destruction of the actual subject matter, destruction of the product. So then a court can maybe hold that individual or that company, that warehouse, they can say they have the defense of impossibility because of destruction. Now, the second one is, I think it's fairly easy, death or incapacitation of one of the parties to the contract. So one party was to perform a contract, but however he died, or he was incapacitation at one point, then that's the courts are going to hold him impossible for him to perform the contract. Now, the third one is the means of performance contemplated in the contract cannot be performed. Now, this one can get rather sticky, but let's just try to bear with me. Say there is a retail company that wants 1,000, that contracts with a wholesaler. A wholesaler agrees to give the retail 1,000 widgets. But before that, the wholesaler contracted with the manufacturer and say, I want to purchase 10,000 widgets from you. Will you be able to deliver 10,000 widgets by Monday? So the wholesaler contracts with the manufacturer, it gets and wants 10,000 widgets. Now they go and make contracts with retailers. I'm going to have 10,000 widgets. Who wants to buy them and sell them to the customers? So the wholesaler contracts with 10 different retailers for 1,000 widgets each. So, but in that case, if you say, I would deliver the 1,000 widgets to you, all you 10 new retailers on Tuesday, because I'm supposed to get 10,000 from the manufacturer on Monday. So on Monday I'll get them, and then on Tuesday I'll deliver them to you. At that point, let's say the manufacturer, something happened in the manufacturer, say that manufacturer company burned down. Then the wholesaler can say the means of performance. In order for me to perform, I needed the manufacturer to deliver to me, the wholesaler, 10,000 widgets, but they did not. Therefore, I cannot perform my obligation to you because I never got the products to deliver to you. That's going to be the excuse or the way to get out of it, by the means of performance. I don't have the way to perform it because I don't have the products. Now, the fourth one is, I'm sure this is an easier one too. The performance or the obligation has become illegal after the contract, but before the performance. So in that example, say for instance, I contracted to buy from a company 1,000 cigars to be imported from the Dominican Republic. If, for instance, the U.S. now passes that cigars from the Dominican Republic are illegal to import now. So then the cigar shop is going to tell me, sorry, I can't. We contracted, but however, before I was set to deliver those cigars to you, Congress or the U.S. made it illegal to import cigars from the Dominican Republic. Therefore, I can't complete my part of the contract because it's illegal now to sell those in the U.S. So that's just a way it can become. They're going to get out of it by saying it's impossible now because of the law, because of the illegality of the law. Well, I hope you understood the impossibility effect. Now, just remember, impossibility, they fall under 4 different categories, and these are the 4: the destruction, death or incapacitation, the means of performance, and of course the service or the product becoming illegal to import in our country or whatever country you are importing it from. Let's go on the next slide and discuss one more of these. Now discussing here slide number 16, still part two of the impossibility. Now the doctrine of temporary impossibility of performance operates to suspend, not discharge, but to suspend the obligation to perform until the impossibility ceases or when someone is able to perform. Sometimes the parties add a clause that contemplates uncontrollable acts that will impede performance under the contract. Now, these clauses are called the force majeure clause or the act of God clause. Now, when it's basically, it's saying right now something happened that it's impossible. There's an act of God that nobody could control, that it's temporary suspends my ability to perform the contract. Perhaps maybe in cities, if a retail wants to sell you something, but there's a riot, there's pandemics such as COVID-19, there's threats of terrorism, there's fires, earthquakes, wars, hurricanes, any of those things. Sometimes maybe they may hold it, they may suspend the performance. However, it doesn't completely wipe out the obligation, but it may just hold it for that moment. If there's, for example, in Florida, when there's hurricanes, perhaps maybe it made it impossible for a company there to perform their obligation at that moment. But perhaps maybe when they're up in their feet again and the hurricane goes away and there's better weather, then they can perform the contract. So at that point, the courts will hold it that this is a temporary impossibility of performance and able to pause the obligation and then revive it again when it's possible again. So let's keep talking about this. Now here on slide number 17, again the discharge by an operation of law, but this time it's going to be impracticability. Now there are going to be certain agreements under which, although performance is not objectively impossible, meaning it could still be done, performance becomes extremely burdensome, and due to some unforeseen circumstance occurring between the time of the agreement and the time of performance, something came up that makes it extremely burdensome. If the burden that arose, if it was unforeseeable and extreme, then courts may allow the burdened parties obligations to be discharged from performance. Now again, it has to be unforeseeable and extreme. Now those are the two elements that the courts need to find in order to discharge the person who wants to get out of the contract. For example, let's say there is a small local pool company. If that pool company builds, let's say, one pool a month in the summer, so they build in June, they're going to build 4 pools. If that company perhaps maybe does their preliminary testing for somebody they contracted to build a pool for $50,000, they did their preliminary test, they checked everything in the soil, and they found that okay, that everything looks good. We'll build it for. It should take us a week. We build a pool a week in the summer, so we're scheduled to build 4 weeks, four pools this month in June. But perhaps maybe once they start digging, they realize 4 feet under the ground of the homeowner's house, it's solid rock. So they realize, oh, there's no way, no pool company would have been able to detect this. We're a small pool company. We build 4 pools a month in the summer, this all of June. In order for us to complete this, we're going to need to dig. We're going to need to put dynamite in the ground to break the rock. We're going to need to get different permits. We're going to get we're going to need different types of professionals, a lot more experienced people. And it just went from $50,000 the cost to now if they tell the homeowner it's going to cost you $150,000 now, because it's going to add, we're going to charge you $50,000, but now just the pool company's expenses are $75,000 alone to try to do that pool. So they would just lose a lot of money. And it was going to take them 30 days to complete the pool. It won't take them a week. It'll take them 30 days, a whole month. They're going to lose jobs, and those 3 other jobs that they did a month in the clutch pool season, and as well as they're going to be losing money. So time, money, and opportunity. So that small company may say to the judge, it was unforeseeable because these are the tests that all pool companies run when they want to build a pool. However, and it was unforeseeable with the tests we did to know that within 3 or 4 feet, it's all solid rock under the homeowner's property, and it's very extreme if we were to go because of all the we're gonna lose money. We can't build it for $50,000. We're going to spend 30 days, a whole month doing this, and we're going to lose out on all our other pool opportunities. And we're a very small company, a local company, and this would just put us under, and we would fail and close up shop if we need to do this. In that case, a judge may hold that it's just impractical to complete this job. It was unforeseeable, and it's just very extreme for the pool company to move forward. So they may let them out in this example. Again, it's hard to judge this because perhaps a judge may say, well, you assume the risk. You should have gone different tests. You should have dug deeper in the ground to run a different test. But that's going to be up to the judge. But it is hard to prove that it's impractical now because it's unforeseeable and extreme. Those are going to be two elements that you really need to prove to get out of the contract. Okay, well, let's go to the next slide and keep discussing this. Here, jumping on the last subject matter slide, slide number 18, we're going to discuss the frustration of purpose, the final and third one of the discharge by the operation of law. So in some cases, events may occur that basically just destroys the party's purpose in entering into the contract, even though performance of the contract itself can still be performed. When one party's purpose is completely or almost completely frustrated or destroyed by supervening events, courts will discharge that party from performing their obligations or their rights or terms under the contract if certain things are met, if three elements are met. One of them is a party's purpose is substantially frustrated without their fault. So it has to be without their fault. It has to be substantially frustrated. Now, some event occurs when the non-occurrence of the event was the central assumption of both parties when entering into the contract. Now, both parties assume that is why they're entering into the contract. And third, the parties have not otherwise agreed. They have not said who's going to bear the risk if such non-occurrence or if such event happens that basically destroys the purpose. Now, one example is this: if, say, for instance, Johnny contracts a hotel and says, I want to rent 2 nights of the hotel room that faces Main Street because I want to see the main parade go down the street for those 2 days. And the hotel says okay, sends him an invoice, and a contract said you need sends 2 nights stay for room facing Main Street to see Main Street parade. Now, okay, in that case, it says, okay, and it says, okay, we need $100 deposit, and the total's $300, $100 deposit now, $200 when you arrive at the hotel. Okay, so they agree to that, and say for an example, a week before, Johnny was going to go to the hotel, they canceled the parade. The parade has some regulatory issue, and they couldn't get the permit, so the parade is canceled. At that point, Johnny calls the hotel and says, I want my $100 deposit back. The hotel sues Johnny and says, no, I want the $200 remaining in your contract that you still owe me. In that case, Johnny's going to argue that it's the frustration of purpose. The principal purpose was not to stay in your hotel, but to see the parade. And what happened was the cancellation that happened. That's going to affect the main purpose of what I wanted to do, and nobody assumed the risk of that. Nobody said, hey Johnny, if the parade doesn't happen, you still owe me, or they didn't tell the hotel, if the parade doesn't happen, then I don't have to pay you anymore. It was silent on that, but Johnny communicated, and the hotel knew that the reason he booked those rooms on Main Street was to see the parade. Now that's probably going to meet the frustration purpose, and Johnny will most likely, it depends on the court, but will most likely get his $100 deposit back. Now, this frustration of purpose, now it's required that the burdened party, Johnny in this case, they still has to show that the event, the parade being canceled, it was still unforeseeable and extreme. So Johnny can say, yeah, we've been talking about it for a whole year. It's been advertised, so I didn't foresee that it was going to be canceled. And it's extreme because the only purpose that I wanted to stay in the hotel was to see that parade. So it's extreme because it changes the whole purpose of me staying in a hotel. I don't want to stay in that hotel if I don't even need it if the parade isn't going to happen. So the court may hold that it's unforeseeable and extreme. Therefore, it meets the frustration of purpose, and Johnny may be able to get out of the contract and get his $100 back. Okay, well that's the last slide on the subject matter for this one. Let's just go into the last slide and talk a little bit of house clean items and conclusion. Thanks, guys. This is slide number 19. Thanks for joining us this week. This was week 7, when we discussed chapter 11, the fourth chapter dealing with contracts. But next week is going to be the midterm week. I will most likely just send you a Blackboard announcement to all the class. It's probably just going to be short answer. I'll probably put it up on Monday. Shoot you guys. It's just going to be PDF. A couple questions on Blackboard, and maybe, I'm not sure, you haven't decided, maybe 4 or 5 short answer questions. I'll leave it on Blackboard, and I'll probably leave it on Blackboard for a couple days, 48, maybe 24 or 48 hours, or perhaps maybe 72 hours, 3 days, or I'm not sure the timing, but I'm not going to make it very time sensitive. I'm not going to make it 1 day or something like that. I'll probably put it for a couple days or maybe the whole week, where you guys have the opportunity to answer those questions. But if you guys have any questions in the meantime, please don't hesitate to reach out. Thanks a lot, guys, and hope you have a safe week. Thank you, guys.